Greetings, my name is Brandon. This is our group presentation for equity and trust. A trust is defined as an equitable obligation created by a settler that binds a trustee, that is, a person that has control over the property being dealt with, for the benefit of another party, that is, the beneficiary. We will be listing various trusts and distinguishing them based on categories, as well as their effectiveness in achieving their respective purposes.
An express trust comes into play on account of an express declaration made by the settlor. The most important elements of an express trust are the three certainties needed to be satisfied in order to create a valid express trust, namely certainty of intention, that is, an intention to create trust, certainty of subject matter, that is, clarity of trust property and beneficial interests, and thirdly, certainty of objects, that is, clarity of beneficiaries. These three certainties were all emphasized in the recent case of Lim Kim Wat and Datuk Johari bin Abdul Ghani 2018 as being the essentials in creating an express private trust, further divided into fixed and discretionary trusts to be discussed later. Express trusts are created for several purposes, including providing for secret beneficiaries after the death of a testator or creating a marriage settlement for the benefit of parties. Implied trust, on the other hand, arises through operation of law. They are created through court interventions that consider the intention of the property owners in recognition of the trust and are divided into resulting and constructive trusts. Resulting trust itself consists of automatic resulting trusts and presumed resulting trusts, according to Justice Magory in Re Van Vel's case 1974. An automatic resulting trust arises when a transfer had been made on express trust but has not completely disposed of the beneficial interest in the trust property. This results in an automatic consequence whereby the courts will impute an intention that the transferee is holding the property for the transferor. A presumed resulting trust arises when property is purchased or voluntarily transferred in the name of another, or by joint purchase in the name of another, or in joint names. It is a default mechanism that occurs when express trust is not invoked on the presumption that the real purchaser has an equitable right to the property, especially when there is no definitive evidence in the first place concerning the transferor's real intention, as per Van der Vel's case. Constructive trusts arise as a residual category when the courts desire to impose a trust and no other suitable trusts are available, as per Tan Sri Datuk Mohan Swami's case 2003. They are broken down into institutional constructive trusts and remedial constructive trusts. For institutional constructive trusts, the role of the court is to declare a pre-existing trust where the person who is a constructive trustee has attempted to deny the interest of the beneficiary. It flows directly from the law and acts to prevent misconduct. For remedial constructive trust, the court exercises its powers in equity and imposes constructive trust as a remedy based on its situation at hand, especially in breach of fiduciary duties. Similarly, it retrospectively creates an enforceable obligation, the extent of which to the court's discretion, and was endorsed in the Federal Court of Malaysia in the Api case 2017. This implies Malaysia's preference towards remedial constructive trust on the basis of preventing unjust enrichment. As express trust gives intention to the deliberate act of a settlor that declares it, therefore its elements of clarity are satisfactory in enforcing it. However, when such formalities are not met, the court's discretion to invoke implied trust helps to enforce unprotected beneficial interests. A distinction stated in Datuk M. Kevia's case 2014. The capacity to imply intention, therefore, provides necessary prevention towards unconscionable conduct.
The first type of trust that can be distinguished this way is the fixed trust. Under the fixed trust, beneficiaries have a definable fixed claim to the property that existed since the date of the creation of the trust. As a result, beneficiaries are entitled to sell, exchange, or gift away their interest, subject to provisions to the contrary as detailed in the trust instrument. As mentioned by Yap, in order to create an express private trust, 3 certainties must be fulfilled: certainty of intention, certainty of subject matter, and certainty of object. Within the 3 types of trust, there are distinctions between the certainty of object tests. As seen in Inland Revenue Commissioners and Broadway Cottage Trust, in order for a fixed trust to be valid, a list of all possible objects must be possible for compilation, also known as list certainty. Thus, the certainty of object test for the fixed trust leaves little to no room for uncertainty. A fixed trust is useful as it is straightforward. Provided it is a valid trust, the beneficiaries will know the portion of the trust they are entitled to and be able to enjoy and protect it as soon as the trust comes into effect. The next type of trust is the discretionary trust, where the trustee must exercise their discretion in order to distribute the property to a selected group of people. This means that on the date of the creation of the trust, the beneficiaries do not have an actual interest in the property, only a hope or spec of acquiring a benefit under the trust. It is only once the trustee has exercised their discretion and distributed the property to the one or more of the selected group of people that they acquire an actual interest in the property. We can also further divide discretionary trusts between exhaustive and non-exhaustive discretionary trusts. Under exhaustive discretionary trust, trustees are required to fully distribute the income and/or capital to the objects. Meanwhile, under the non-exhaustive discretionary trust, this is not a requirement and the trustee may retain or accumulate the relevant property at their discretion. In the case of discretionary trust, the certainty of object test originates from McPhail and Doughton and is the criterion certainty test or in or out test. This means that the trustee must be able to determine with certainty whether any given claimant is or is not within a relevant description of the class. This is less strict than list certainty test, as while the list certainty test requires evidential certainty, the in or out test will be satisfied as long as there is no conceptual uncertainty. There are several reasons why someone might want to create a discretionary trust. Firstly, it is able to react to the changing circumstances and needs of the potential beneficiaries and adjust the interest given accordingly. Secondly, discretionary trusts provide protection from creditors. Prior to the exercising of the discretion of the trustees, any interest exists only as a hope of acquiring a benefit. Because of this, the trustees in bankruptcy are not entitled to a share of the trust fund. The final type of trust is the protective trust. A protective trust is a life interest given to a person which will become a discretionary trust in the event of something occurring which is prohibited by the trust instrument, such as the bankruptcy or alienation of the beneficiary. The property will then remain in the hands of the trustee, who can use their discretion to distribute the property. A protective trust is created either when the settlor expressly sets it up in the trust instrument or by incorporating Section 38 of the Trustees Act 1949. Firstly, protective trusts ensure that the beneficiary receives continuous support. They also protect against the beneficiary's improvidence or incapacity, similar to the discretionary trust, while offering more flexibility. Under the discretionary trust, it can be said that beneficiaries are at the mercy of the trustee, as whether they receive interest in the property is fully up to their discretion. Meanwhile, a protective trust allows the beneficiary some enjoyment over said property prior to the determining event.
Bare trust is the kind of trust where all the trustee has to do is hand over the trust property to the beneficiary at a determined time. He has no other active duty beyond this, as decided in the case of Saunders and Vautier. There are 4 circumstances in which the doctrine of bare trust can be applied in Malaysia, which are the existence of a valid contract, the purchaser having to carry out and fulfill all obligations under the contract, the vendor must have the title of the land, and finally, the vendor does not have the duty to perform other than those executing the transfer and perfecting the transfer document. Bare trustees do not have any duty to comply with other directions when performing in relation to the trust. Rather, They adopt a minimum legal interest that serves to convey the trust property on demand with no general power of agency, only serving passive duties such as loyalty and honesty. This facilitates conveyance or dealings related to property for a bona fides purchaser's interest. In the federal court case of the Mangung Securities Limited, after the full payment and surrender of the possession, the vendor would then become the bad trustee. And in the case of Ong Chat Pang, when the vendor has done all that is necessary to direct himself of the legal estate by executing a valid transfer of the land, he then becomes the bad trustee too. On the other hand, a special trust is when where the trust itself imposes active duties on the trustees. For example, a trust for sale. Such trust may either be ministerial or discretionary, the former merely requiring the application of ordinary intelligence and business aptitude by the trustee, the latter calling for a greater element of judgment and discretion, as where it lies with the trustee to determine how much of the income of the trust property should be paid to each beneficiary. Special trustees are therefore called upon to exert themselves in active execution of the settlor's intention, either existing or implied from circumstance. In the case of So Chi Yi, it was held that a very senior employees are in possession of special trust and will almost necessarily incur extensive fiduciary duties to the employer. The difference then between bad trust and special trust lies in the duty. Converting a special trust, such as a life trust for example, by terminating and restricting duties to property conveyance produces a bad trust. But inversely, directing a bad trustee to hold new trust of active duty is more difficult as it amounts to subsisting equitable interest that must be in writing. Additionally, bad trusts are sourced contractually from the agreement itself, whereas special trusts are sourced from terms of the trust related to the property instead of just the agreement itself. In essence, a bad trustee's minimal duties are sufficient to protect a purchaser's beneficial interests, whereas special trusts are adequate in enforcing constant performance of duties that are more extensive and specialized.
The trust that takes effect is divided into an inter vivos and a testamentary trust. The case of Tan Chong Kiat against Kwan So in 1998 provides a definition for an inter vivos trust, which explains it further as a transfer of property to another gratuitously without the expectation of death, thus whilst the donor is still living. It is considered as a voluntary transfer without consideration and the expectation of any returns. Although this trust can appear as a gift or a transfer, it commonly emerges as an inter vivos gift. Statutes provided under Malaysia governing this trust are the Civil Law Act 1956 and Financial Services Act 2013. Essentially, inter vivos trust constitutes of living trusts overall, where the heirs can acquire a donor's estate without the need of a death of a donor. These trusts are often advised to be utilized for estate or tax planning, as well as mitigation of risks of personal estates. Additionally, these trusts do not die. Thus, estate duty and executories are not required. On the other hand, testamentary trust is created through testamentary instruments, which usually is inclusive of a will. Hence, the elements of a trust are dependent entirely on the validation of such instruments. Rigobian Kian Settlement Trust in 1968 constitutes of Lord Reed's words, where the settler must be relying on the trustees based on a fiduciary capacity, indicating that the requirements in executing testamentary instruments such as a will is accounted for. Conversely, unlike an inter vivos trust, this trust only takes effect after the death of the settler. Malaysian cases illustrating this are found in Ri Ismail bin Renta in 1940 and Li Ying Chin against Ganyuk in 2004. Gopal Sri Ram in the latter case determined that the will would take effect only after his death and is thus a testamentary trust. Wills Act 1959 and Probate and Administration Act 1959 is extremely likely to be implemented for testamentary trust. A category under testamentary trust would be secret trusts, although it differentiates itself where testamentary trusts are valid without the need for consent of the trustee, in comparison to secret trusts. As a function of a testamentary trust only takes effect upon the settler's death, executor's fees, as well as the taxes that are not required for an inter vivos trust, is likely to apply for this trust. One would form a testamentary trust, often to avoid the Distribution Act 1958, which limits the inheritance towards only family. The Singaporean Court of Appeal case Lim Sui Hong Catherine against Lim Ju Hian Anthony in 1999 suggested that an inter-vivos trust can exist side by side with a testamentary trust, and the seen in Malaysian case Amaravati against Siva Prasangam in 2001. Nonetheless, the courts make a clear distinction on the trusts that are classified as inter-vivos or testamentary. A more recent case in Malaysia, Gwindaraju against Sat Gunasingam in 2010 establishes whether the gift was inter-vivos or testamentary, in which it was an inter-vivos gift. Conversely, the use of the Civil Law Act 1956 is seen in Manomani against Great Eastern Life Assurance Company in 1991. Dr. Haji Muhammad Yusuf bin Chinjay uses the act to contend that monies paid were not part of the estate of the deceased, and whilst the settler was still alive, and thus it constitutes as a living trust. The application of testamentary trusts is illustrated in Chu Chun Fat and Anor against Yam Shirley in 2018. This case references Li Ying Chin against Gan Yu Chin in 2004, which establishes the testamentary gift is formed under the observation of the requirements of the Wills Act 1959. The 2018 case also quoted Scott's work, The Law of Trust, where it stated that it would clearly be testamentary trusts if the beneficiaries do not acquire any interest in property prior to the individual's death. Again, this is also invalid if there is no compliance on the requirements of the Statute of Wills.
I will be distinguishing on trusts based on type of beneficiaries, that is, public and private trusts. Public trust is synonymous with charitable trust in Malaysia. In the case of Satuana Kana, a trust was held only to be public if it had a charitable purpose. Two conditions are therefore required to form a charitable trust. First, a charitable purpose. Instead of following a fixed definition, the courts have a duty in determining whether each purpose in question is considered charitable. In the case of Satuana, the PEMSEL rule was adopted, laying down 4 heads of charity: relief of poverty, advancement of education, advancement of religion, and other purposes beneficial to the community. The element of public benefit is therefore crucial in labeling an act charitable. The case of Riyal Sagaf Trust even held that a gift to a person reading the Quran in the testator's name had no public benefit, whereas providing mats and water to the mosque was charitable as there was public benefit, even though both acts were under religion. The second condition is that it benefits a section of the community, as per the case of Oppenheim, which was also stated in Tatuana. The quality of the community must not be reliant upon a relationship with any particular individual. As long as they are by themselves a distinguishable, non-negligible part of society, the courts will allow for it. Private trusts, on the other hand, are more personal in nature. The beneficiaries must be particular ascertainable individuals, as stated in Ri Chong Kehu, or be in reference to some personal relationship, as stated in Oppenheim. All of this is to help show local standard. For example, in Tatuana, the trust was held to be private as it benefited 52 specific orang asli and their direct lineal descendants to receive the trust fund. There is no requirement of public benefit whatsoever, as private trusts function to preserve present and future interests related to personal property. There are several advantages, therefore, experienced by charitable trusts as compared to private trusts. Charitable trusts are not subjected to a typical test of certainty of objects. Instead, it only has to be proven that the trust funds promoted by the institution are used exclusively for charitable purposes. While less strict, it does deter certain trusts from actually being charitable. For example, in Lin Chui Chuan, the social purpose of a temple was held to be too vague and therefore could not be considered solely charitable. Trust objects can therefore only be valid if they are confined to a charitable nature. Other advantages of a charitable trust include freedom from income tax under the Income Tax Act, which reduces upkeep, along with being enforceable by the Attorney General under the Government Proceedings Act, giving beneficiaries the chance to be privy to government expertise. Additionally, the courts have ruled charitable trusts to be exempt from the rule of perpetuities, against perpetuities being able to last indefinitely. While typically the rule prevents property from being tied up in private trusts, charitable trust functions to promote a public good and are therefore facilitated by these various advantages. Unsuccessful claims of private trusts as charitable trusts are known as private purpose trusts, where there is a purpose rather than a beneficiary involved as the trust object, which was pioneered in Re Aster. While unenforceable, several anomalous classes of private purpose trusts have been deemed valid if the purpose is defined and within the perpetuity period, such as gifts for Sinchu purposes in the case of Ku Cheng Tiao. Courts may therefore give concessions for such matters. Ultimately, charitable trust provides a wider and more consistent aid for donors to effectively achieve their objectives, whereas private trust functions sufficiently to secure and manage property for personal enjoyment. In a nutshell, while all the trusts presented consist of distinguishable elements, they are all individually important to achieving different goals. The mechanisms of these trusts therefore function well in protecting the equitable interests of beneficiaries within different contexts. That's all for our presentation. Thank you.